So we already heard we have on this panel Don G.Cornish here to my left. He's a governor representative of the Bahamas, and he works as a governmental and business consultant with experience and service in the Grand Bahama office to the Prime Minister. Then in the middle, we have Dennis Mark Gauci. He's a partner at KSI Malta. He's in charge for international clients, and he assists international clients in their marketing strategies and internationalization processes to use Malta as a hub for Europe and North Africa. And then on the very left, I welcome Dr. Josef Cachia. He is head of legal at KSI Malta. He is specialized in corporate and commercial law, and he advises clients on drafting commercial agreements. Welcome to the panel.
Thank you.
So first of all, what I would like to talk about this morning is regulatory frameworks in Malta and the Bahamas. Malta has, about a year ago, that was when Malta introduced the DLT framework, which consists out of 3 bigger policies. And maybe you could tell us a little bit more about the Maltese DLT framework.
Okay. So firstly, a pleasure to be here. This is a very interesting opportunity. Firstly, the laws in Malta came into force about November last year, so it's a bit less than a year. And we split the laws in 3 specific sections, the most important being what we call the VFA Act, which essentially regulates ICOs and service providers like your traditional exchanges and broker-dealer platforms. Then we have the MDIA Act, which essentially establishes a new regulator to deal with DLT technology. And then we have the ITES. It is a regulation dealing with what we call innovative technology arrangements, which are technological arrangements based on DLT. The idea being that it is not just the tokenization itself which is regulated, but also the technology itself. Because it is very important that the technology does exactly what it says that it does in relation to security, immutability, timestamping. So the purpose of the ITES is then to ensure that when such technologies are put on the market, they are audited by a new entity called the system auditor, which would be technical experts, to be sure that the technology functions accordingly.
And the Bahamas are also in the process right now of releasing a DLT framework. Don, could you tell us more about that?
Yes, we're very fortunate to have the relationship between the private sector and the government in developing the digital assets resources exchange bill. And actually the acronym is DARE, and it's quite daring to begin with because we've been in the business of financial services for close to 100 years, and as a financial services jurisdiction, one of the concerns that obviously we faced was how do you bridge the two, because this dynamic space we call blockchain crypto is moving very, very fast. And so we've had a chance, there was draft regulations last year, a year ago, and over the last few months, we completed the actual act, which is in its last stage before it becomes law. And so we're very fortunate that there's going to be a new process to integrate these 2 industries in a way that it's virtually seamless, but will provide the right kind of platform for persons who want to engage in blockchain and cryptocurrency. So it's probably a few weeks away. By the end of the summer, we expect to be fully in the industry and able to provide the platform that many persons would best want.
And would you say that the framework is quite similar to the one in Malta, or is it very different?
But based on our discussions, obviously very similar. I think one of the advantages that we have is that I think there's an immediate recognition of the classification of tokens, and that's one of the concerns that many persons have, whether it's a utility token or it's an NFT or it's a security token, and making sure that people understand the difference, and also bridging the gap between securities trading and the token business and registration. The way that the bill is designed is for the private sector to have an entity called a sponsor. That individual will be, of course, a citizen of the Bahamas qualified to provide the service of registering the entity. registering the asset, whatever token or exchange you wish to engage in, all of the applications are sent to the sponsor. The sponsor has a duty then to ensure that there's compliance with the AML, KYC requirements. In addition to that, the memorandum and everything else has to meet the standard. And if everything checks out, then there's a 45-day turnaround. A certificate of compliance is issued. That certificate of compliance then is presented to the Securities Board for proper licensing and registration. The sponsor would be sufficiently qualified to reject an application as well. And so I'm very excited about that whole idea because the industry, as you know, basically is struggling with a number of issues, including the fiat issue. How do you translate from the token business to fiat, if in fact persons want that flexibility and bringing it from the digital space into traditional banking space, as the case may be. Many jurisdictions struggle with that, especially with having access to a bank account and those kinds of things. The bill speaks to that. So I think there's a very clear and a very deliberate direction in what we're seeking to do in the Bahamas, and I think it's going to convert basically into an international language that we can all understand, because there has to be some kind of integration between the various countries where we're challenged by this industry and this movement. It's moving very, very fast.
So you just mentioned that in the Bahamas there's going to be the function or the role of a sponsor, and in Malta we have something fairly similar, I would say, which is the VFA agent. Dennis, could you maybe tell us more what a VFA agent is, and also KSI Malta is actually operating as such an agent, right?
Well, basically a VFA agent is a firm, a legal firm, or a corporate service provider firm, which is licensed by the authority to act as an intermediary between the client and the authorities. So basically like the sponsor in Bahamas. So basically what we do is we do a financial instrument test, determine the type of token, and then present our legal opinion to the regulator. As a firm, we have the clients to draft out the memorandum, set up in Malta, and then obviously get the license necessary to issue the token from the Maltese Islands. But basically, it's the same principle like Bahamas is doing, and I agree with my colleague here that the jurisdictions need to talk between them so as to make a sort of standards where each token is recognized the same in every jurisdiction, hopefully.
And Malta is part of the European Union, so what is the opportunity but also the threat here? Because the European Union could just come in and craft its own DLT regulation, its own blockchain regulation, and that could render Malta's regulation useless.
My personal opinion is that Malta tries to emulate what happened in gaming. We were the first jurisdiction in the world to regularize gaming some 18, 19 years ago. We did so even in blockchain. We're one of the first countries to regulate this ecosystem. We are continuing to improve our bills. We will soon be launching a fourth bill, aims to give the legal rights to decentralized autonomous organizations. We also have actually now white papers on cybersecurity, artificial intelligence, and IoT. So what we are trying to be is to be trendsetters. So and we continuously evolving, obviously taking into consideration what other jurisdictions are doing, and obviously the European Commission, their guidelines, and maybe when the European Union will have its own opinion, it will comply with us, with ours.
So at the end of the day, in a couple of years, probably all those countries around the world will have to come together to actually craft a legislation to actually make those services and those tokens interoperable, so you can actually then trade a token from the Bahamas to Malta, but also to any other European country or to the US. So what do you, that's a question to all of you, where do you think this is headed?
But I think that's going to happen. One of the things that we talked about earlier, as we had a chance coming in, I guess we were in the waiting room, we were able to talk about integration across the various jurisdictions. The reality is we live in a world where there's, communication happens very quickly, and also people are aware of what exactly they can do in any given country. given the threat of money laundering and terrorism and the other issues with KYC, one of the things that I think has to happen is just like with any trading environment, whether it's the traditional trading with NASDAQ or some of the other exchanges, in this space, I think eventually we're going to have to look at how do we have conventions between ourselves to provide the kind of environment where we don't have challenges trying to manage all of the, I guess, the rogue activity in the space. And so it's going to mean that the bigger countries, the smaller countries are going to have to sit in the same room, come to an understanding, and create an environment where it's much more productive to get involved in the space and the integrity is not lost at the end of the day. If you have 50,000 exchanges, that's a whole lot of management, you know, and so we don't want to overregulate. We also want to make sure that persons who are not appreciative of the dynamic movement in the industry can also be safe and feel comfortable investing with a trading platform in the digital space because the language is the same everywhere.
What's the Maltese take on this? Maybe Joseph, you want to?
I think the most categorically important thing is, as we were mentioning earlier, is token classification. This is something that essentially we were talking about before coming here. But it is very important that globally regulators agree on the terminology on what exactly is a utility token and what is exactly a security token. We do not want a situation where the Securities Exchange Commission in the United States decides that this token is not a security or is a security, and the European Commission states otherwise. Because this would lead to a situation where a token is in fact a security in Europe and not a security in the United States or vice versa. This would lead to issues in relation to regulation, how this will be dealt with, on which exchanges can be traded on. For example, in Malta, one can get a license as a securities exchange under MiFID, but there is a completely separate license for a VFA exchange for cryptos. These are completely separate institutions which need to be separate functionally and even operationally. So it is important that we are able to agree on the language on token classification.
Malta has also got together with a couple of other southern European countries, I think Greece, Spain, France, and Portugal, to form an alliance when it comes to the regulation of tokens. Can you tell us more about that?
Well, that is actually a memorandum which the idea of itself is to promote the sector. For example, the Registry of Companies in Malta has embarked on a project whereby its idea is to put the Registry of Companies on the blockchain. So ideas like this, their purpose is to promote the DLT and use the power that this technology provides us and to be able to put other systems on the DLT. This would include certificates from the universities and anything of the sort, like public registries. Going on to the DLT gives a new meaning, a new strength to these kinds of departments because of their permanence, their mutability, their protection, which traditional registries do not provide.
So what we can see is that Malta is not only crafting legislation to welcome blockchain companies, but that it's itself also embracing blockchain and using blockchain as a technology for governance. And that's also something we can actually see in the Bahamas, correct? Because now there's the plan for the sand dollar, and maybe Don, you want to tell us more about the sand dollar?
Yeah, the sand dollar virtual currency, the Central Bank of Bahamas has looked at it, and it's in the testing stages with a view to creating an environment where persons can move toward not necessarily a cashless society, but to use less cash. And I think one of the advantages of the currency is that it will provide an opportunity for movement in areas, especially in the Bahamas, the nation of islands. We have 700 islands in some remote areas, and this will be quite good for many persons who don't have access to a traditional bank environment. You can have a point of sale and basically get access to services and products that you need. And in these areas, we have a nation of 100,000 square miles, so it's a very large area, some sparsely populated areas. And so it's really progressive trying to think of ways in which you can bring services to these kinds of environments and also to provide benefits for those persons. And notwithstanding the issues with security and safety and everything else, it's going to be within the virtual space, but it also comply with all of the requirements as far as the traditional KYC requirements as well. But the step is progressive, and we're hopeful that this will be a good way to begin the whole discussion about virtual wallets of all kinds, because then if the central bank is leading this kind of discussion, then it creates an opportunity for expansion in a way that will be beneficial to a larger part of the population as well as the international environment.
Okay, and another question I have regarding that is because the sand dollar is being developed by an IBM venture. So is that going to be, are they going to develop that in an open source standard, or is it going to be a closed system? Can other people actually also develop applications for the sand dollar, or is it going to be more of a governmental issue?
No, the sand dollar will not be open, but I think, as I said, virtual wallets and the like will have an opportunity. I think you'll see some kind of integration take place, but it's a test program for the time being, and launches in 2020. And the whole idea is for it to be an internal system for the time being, and then I think over time integration will happen, just like with the Visa, MasterCard, or some of the other transactions you can do. I think obviously you'll have to have it, I guess, coded or provide some kind of protection so that it's not infiltrated from the outside necessarily, but it'll be integrated into a framework that is translatable.
Okay. Another topic I would like to talk about is AML, because the European Union and also the IMF have actually raised concerns regarding AML with the new DLT framework in Malta. And maybe the two of you could tell us more about that.
Well, the statement from the IMF essentially highlighted two things: the importance of doing proper KYC, and also it raised concerns regarding regulatory enforcement from the local authorities. In our case, it would be the MFSA and the FIAU, which is specifically designed to cater for money laundering. In relation to KYC, I would say that the tools are there. With DLT coming to Malta, also the players in relation to KYC for DLT have also set up shop in Malta. So there are possibilities, not even just to do the basic KYC on the ultimate beneficial owners, which has already been there for years, but there are also solutions catered specifically to do KYC for wallets. So now you can go to a provider, even to an API, which they provide the service as well, and they will do a KYC on the wallet itself. So they will see the origins of the tokens which the wallet originates from, and they will see the strength of the wallet coming in, delivering its tokens to the exchange, for example. In relation to enforceability, I say the main concern there, I am sure, is in relation to the resources the FIU and the MFSA have. Currently, there is a big recruiting drive from the authorities, and I am sure, as happened in the past with gaming and traditional financial services, that the authorities will rise up to the challenge and get the stuff that they need to do proper enforcement. Like gaming and financial services, the authorities have proven themselves to be strong, and I think for the DLT, the authorities will also rise to the challenge in this industry.
Okay. But the DLT framework in Malta has also seen some successes, because we had Binance and OKX already opening up their offices in Malta. Maybe, Dennis, you want to talk more about that?
Yes, actually the Prime Minister tweeted, welcome Binance to Malta about a year ago. What the government did before issuing the laws was to consult with the private sector, not only with the Maltese tech lawyers, but also with large exchanges and the largest game changers in the system. So Binance and OKX and other exchanges are set based in Malta. They obviously consulted with the government to be able to have the proper laws, but also to be business driven, because obviously we don't want to over-regulate the space in a kind that no business comes to Malta. So actually now at the moment Binance are the advisor for the local stock exchange. Hopefully by the end of the year we should have also exchange accepting DLT and blockchain companies on it. So yes, it seems that Malta is going in the right direction to try and be a major player in this ecosystem.
So we've seen big exchanges in Malta. What do you think, what kind of business is going to come to the Bahamas when the new blockchain regulation framework is being passed there and done?
But we hope that we're able to be a major player and people can feel comfortable coming to the Bahamas to do business. Just like we do in financial services, we have around 300 international banks and financial institutions in the Bahamas. So given our history as a financial services center, and we remain in that position, I think that persons who are involved in major investments in blockchain cryptocurrency will feel comfortable in the Bahamas. We have the capacity, and basically what we're looking at is trying to translate that into a platform where persons who are involved in blockchain crypto can feel comfortable in the Bahamas, given the kind of capacity that we already have. And so we're looking forward to attracting persons, especially those persons who have challenges from the fiat side, so that they can operate international businesses in the Bahamas without having the bureaucracy that they would have in some other jurisdictions, having to find a third party in order to get basic financial services for their businesses. And so we're optimistic that persons will register their companies. It's a very seamless process, and that they will also do business with us in the way that we've done traditionally.
Yeah, on the fiat side, I think that's when it comes to the banking services in Malta, that's a problem startups or companies have been struggling with in Malta, because they struggle to open actually bank accounts in Malta.
Yes, it's not only in the blockchain space, it's a general rule at the moment. It's very difficult to open bank accounts in Malta. FATF rules for AML, financial terrorism. So basically what the banks did, the Maltas have a different from other jurisdictions. So they have appointed intermediaries that will be, again, an intermediary between the client and the bank. So for example, whenever a foreign client wants to open a bank account, we will open their account on his behalf with the bank. So they shift the onus onto us to do the KYC, the source of funds, and present the application to the bank. It takes some time. It is not difficult to open, it takes some time. It takes 3 to 4 months to open a bank account, honestly. In the meantime, we use electronic money institutions because the clients need to operate. But once we have established the relationship, and once we have established open the bank account, it's up and running. So it takes some time. Obviously, it's a risk-based approach. We know what's happened with ICOs, so the banks are reluctant at the moment to open bank accounts immediately, so it takes time. Another pitfall which we have is that the banks lack manpower, lack the knowledge, the people who will understand what's behind the technology and what the client is proposing. So at the moment, manpower and bank accounts in Malta are the two major issues that we have at the moment.
Okay. So now I would like to open the floor for Q&A. So if anyone in the audience has a question for the panelists regarding global blockchain regulation, please raise your hand.
Thank you. This is a question for the gentleman from Malta. You mentioned that Binance is now advising other exchanges. But Binance exists because they created the Binance token in order to finance the company. And now that token is inside being used as a utility token. Yet for the last hundreds of years, exchanges have been able to function without an internal currency that fluctuates randomly in the market and way more volatile than any other currency. Is that the kind of model you're interested in to go into other industries? What is your view on that? Like, Amazon doesn't charge me an Amazon stock for discounts to buy from Amazon, which is a model I always struggle with in the crypto space.
No, basically what I meant earlier is that the government is being held by Binance to try and to have a securities exchange, official exchange where the security tokens can be traded. So at the moment, I think we are very back in the work. It should have been done already, and I think that it should be done by the end of this year.
Maybe then I have one last question for the panelists, because Europe and the US are still developing their respective regulatory frameworks for DLT. So how does your wish list look like? What would be the perfect global DLT regulation?
I think the most important thing, as I was saying before, is regarding to classification. I would hope that the European Commission and the SEC agree on what would they see to be a utility token and what they would see to be a security token. Everyone knows today what is traditional equity, what is debt, what are derivatives, future options, swaps. So the language for traditional securities exists and it's understood throughout the world. However, for DLT assets, the situation is different. The SEC has taken a much wider approach on what it considers to be a security token with the how it is. It's more they are more tended to put a token in the securities category, or rather than for example the approach that we have taken in Malta. Malta, for example, we have taken a MiFID-based approach. We essentially look at the definition listed under MiFID, all the points that would fall as a transferable security derivative under MiFID, and we've classified a token based on that. In relation in the United States, they took a more arbitrary approach. There's some more discretion involved, so there might be some divergences in what they would call a security vis-a-vis what Europe would call. So generalized approach on an agreement actually on what would be a security token and what would be a utility token, I think is crucial, since it would help everyone wanting to get into the sphere. I don't think anyone would like to go into Europe and telling him, listen, this is a utility token, then going in the United States and telling him, no, I don't care what Europe says, this is a security token. And they have to go through traditional securities regulation. That would be something that I think everyone would try to avoid.
What about you, John?
But I think we're kind of progressed to a point in Bahamas. For example, we have a local company that tested the securities board already, called PO8, and you'll hear from the CEO of PO8 sometime during the conference, Matthew Arnett. We got a no action letter for PO8 from the securities board, I think, which is very progressive. It speaks to the fact that I think there's an understanding. If you look at the legislation that's being proposed and it's going to come on stream very soon, the classification is very, very clear as far as the NFT and security token as opposed to utility tokens. And so that's going to be very easy to translate, because at the end of the day, that sponsor has a duty to ensure that at registration you're very clear on what entity is being licensed. The licenses are going to be very streamlined and very specific. It's not going to be a just broad token license. If you want to be a utility, it's going to say very clearly in the memorandum what it is you're registering. And so that process is going to be quite interesting, because it means then that if you want to invade another space, you have to get permission. You can't just make a decision, I have a token business in Bahamas, I have an exchange. It's very clear exactly what entity is being brought into that space. And so we're excited about that, and I think it's going to, we're learning lessons from what has happened in the past. Malta led the way, and we hope that we can learn from each other, but also that we can avoid those kinds of pitfalls as we go forward. So PO8 is really setting the example in that space. They're testing it already, and we hope that this is going to be the beginning of some very special activity in the token space in the Bahamas.
One last comment from Dennis.
Oh, basically, I agree with my colleagues that there should be some sort of standard between jurisdictions to have a clear guidelines on the tokens. All jurisdictions are doing fine: Bahamas, Estonia, Switzerland, Dubai now, France soon. So it's actually choosing the right jurisdiction who adds value to a project. In Malta, we have great tech lawyers, pro-business, the government easily accessible. We have a solid government which has a majority in the parliament, so laws can be passed immediately without having any bureaucracy. So at the moment, I think all jurisdictions are heading in the right direction. We just need to find a way how to collate everything in one place.
Okay. Can we please have a round of applause for the panelists? Thank you very much.
Thank you.